Good afternoon, everybody. My name is David Johnson. I am the Executive Director for the Center of Ethics and the Rule of Law, or as we like to call it, CERL, at the University of Pennsylvania. Thank you for coming. We have a wonderful presentation and an exciting book talk here. One quick plug I'm going to put out there is for any students that have not had plans for the summer, we still are accepting intern applications for an exciting program we will be running through the summer. But without any further ado, I'm going to turn it over to Professor Claire Finkelstein, who is on the faculty here at the University of Pennsylvania Law School and also the founding director for the Center of Ethics and Rule of Law. Claire.
Thank you so much, Dave, and I am so delighted to introduce Professor Michael McConnell. He is the Richard and Frances Mallery Professor and Director of the Constitutional Law Center at Stanford Law School and a Senior Fellow at the Hoover Institution. From 2002 to 2009, he served as a circuit judge on the United States Court of Appeals for the 10th Circuit and was confirmed by a Democratic Senate by unanimous consent. That's a rarity. The book we'll be discussing today, The President Would Not Be King, Executive Power Under the Constitution, was based on the Tanner Lectures in Human Values, which Professor McConnell delivered at Princeton in 2019. He has a new book about to come out, co-authored with Nathan Chapman, called Agreeing to Disagree, How the Establishment Protects Religious Diversity and Freedom of Conscience, which will be published by Oxford University Press, supposedly this year. He has argued 16 cases in the United States Supreme Court. He is also senior counsel to the law firm of Wilson, Sonsini, Goodrich, and Rosati, and is co-chair of Meta's Oversight Review Board. Please join me in welcoming Judge Professor McConnell.
Well, I'm honored to be here at what I think is the nation's oldest law school.
That's right.
Is that right?
That's right. We are thrilled to have you here, Judge, and so excited to talk to you about your book. I have started working on presidential power myself, and when I came across your book, I could not put it down. It is, bar none, the best book that I have read about presidential power, and an extraordinarily careful, scholarly, yet very readable book about Article 2 and proposes a way for us to understand Article 2, which was very hard for me to deny once I had read it.
You're very kind.
Of course, this topic of presidential powers has been very much in the forefront of all of our consciousness now for a number of years. And even before, of course, the Trump administration arose, because we were all talking about presidential powers really from 9/11 on. It's been a central topic of discussion. And I would say that in a number of domains, the country has struggled with presidential power increasingly. Enormous number of confusions have arisen. The country has been grappling most recently with issues connected with executive privilege, with war powers, with impeachment, with questions like, can a sitting president be indicted? And so on and so on. So we're going to clear it all up for you today. And I just want to begin by asking you to talk a little bit about the framework that you propose in the book. And let me start introducing it in light of Judge Jackson's famous concurrence in the Youngstown case. I teach this case every year to my national security law class, and we go through the famous tripartite theory that Judge Jackson has, which is if Congress agrees with the president, then the president is acting at the height of his authority. If Congress is silent, then the president acts with a little less strength, and if Congress disagrees with the president, then the president is at the lowest ebb of his authority. And we teach this sort of like a shibboleth. Everybody learns, if they learn anything about presidential power, they sort of start with that. One of the most striking things is in a few quick pages, you demolish this concurrence. Tell us why and how it's wrong.
Well, the discussion of the Jackson concurrence comes well into the book. It's more the capstone than, it's not my starting point, but I'll start there since you start there. It's always struck me as a very frustrating three-part test because it appears to be saying something and really isn't. In fact, I think it's more misleading than it is anything else. Now, the first part, that when Congress has agreed explicitly with the president, I think there's very little problem with that. That generally means that Congress has delegated power to the president. Now, there are constitutional arguments about how much delegation is too much. The three-part test kind of ignores that, but beyond that, that's not that much of a problem. The third part of the test is it suggests that when Congress disagrees with the president, that the president almost always loses, and that's just not true because the Constitution vests certain constitutional powers in the president, and when Congress goes against those, that Congress is acting unconstitutionally, not the president. Now, what are they? That's a very important question, but the three-part test doesn't begin to tell us what they are. It treats it as if every conflict between the president's acts and an act of Congress are necessarily in the same boat, and they just aren't. But the worst part of it is the second part, which is where Congress is silent. And here it really gets mysterious because Justice Jackson even calls us, it's in a zone of twilight. So we're the twilight zone, and I wish I could sort of sing for you the tune from the Twilight Zone, because that's what I always imagine happening when I read this part of the opinion. And of course, most cases are in the Twilight Zone. Most cases are in the second category. And what does Justice Jackson tell us to do with that? He says he says that you look at it in light of contemporary imponderables. Well, if they are imponderable, how are we supposed to ponder them? That's what I want to know. And he goes on to say, and I think even more disturbingly, he says that they should be decided in light of the contemporary imperatives, the imperatives of contemporary events. Well, I think that's not just not helpful, but it's positively wrong. That's exactly what courts should not be evaluating, because the imperatives of events are always what's happening today. And so you evaluate presidential power according to the particular dispute that may be before you today. But you're setting precedent for tomorrow, and the contemporary imperatives are going to look rather different. So my favorite example of this is when Jimmy Carter abrogated our mutual defense treaty with Taiwan, with the Republic of China. And they went to the DC circuit and they announced, I believe it was a 13-part test as to when the president can do that and when he can't, and it turned out he could. Goes to the Supreme Court. Supreme Court wasn't quite that bad, but they did fracture various ways. But when the smoke clears, President Carter was permitted to unilaterally abrogate the mutual defense treaty with China without having to go to Congress or the Senate. Well, as you can guess, liberal Democrats were very pleased with that. They liked him. They liked rapprochement with China. This looks like a very great thing. But then, what happens next? Well, George Bush abrogates our ABM treaty, unilaterally. And suddenly, all the people who wanted unilateral presidential power before, suddenly the imperatives of events are looking rather different. I think it's essential in looking at separation of powers problems not to locate them according to the particulars of the occasion. And then there's the fact that this idea of congressional silence is very strange, because what Justice Jackson says is that congressional silence can invite presidential action. I think that's a very dangerous notion. I don't think congressional silence invites anything. I think it is silence. It is Congress not doing something. And the idea that when Congress doesn't do something, it invites presidential action, I think is actually rather dangerous. Even when it's a president that some of us may like. So presidents frequently say, Obama said it, Trump said it, that Congress hasn't acted, and so I have to step in, right? But oftentimes when Congress hasn't acted, the president has no business stepping in because he doesn't have the authority to do it. And the fact that Congress hasn't done it is not a reason for the president to have more power than he would have otherwise. So that's my critique of the test. Now the book, as I said, that's way into the book, and I provide an alternative way of looking at this, but
let's
we would
talk
have to
about
begin
that.
at the beginning for that.
Right, so let's go back. Now, the reason I wanted to start with Youngstown was because it was then that it really clicked for me what you were talking about, because then I understood, oh, of course, right? Whether or not the president has the power to do whatever it is not dependent on what Congress is vaguely thinking, right? And we start looking in this Jacksonian framework, we start trying to read the tea leaves. What is Congress really thinking,
and
right?
Justice Jackson uses the term, he calls it the implied will of Congress.
The implied will of Congress, right,
How do
exactly.
you
We
even know
start
what they're
scratching our
implying?
heads and trying to
What we
figure
know
out.
is what they pass.
Exactly, and that's all we know. So now going back to the beginning, as you say, you have a rather different framework, which has to do with your theory of Article 2 and 3 different categories of presidential power. So let's go to that.
Well, the title of the book really says it all, because what the framers were confronting was a very hard problem. There was no executive under the Articles of Confederation. We fought the American Revolution without an executive. There were committees. So there, John Adams was the chair of the War Committee, and so if any of you have ever been on committees, you can guess how effective this was. I mean, we won the war in spite of, not because of our form of government. And everybody came to the realization, and I don't think there were any dissents from this, to the realization that we needed some kind of an effective executive. The word that they like to use is an energetic executive, and I think that's a good word, because energy, it shows that the executive has to have it's both active and powerful at the same time, right? But they had, on the other side of the coin, the worry that they might be creating a king. And we had just rebelled against a king. That was not, and even more than a king in a way, what they really worried about was Julius Caesar. And I can prove to you that Julius Caesar was on their minds, because the leading opponents of the Constitution, writing under pseudonyms, they almost all wrote under pseudonyms, some of them quite comical. The leading opponents of the Constitution were Brutus and Cato.
Right.
And that tells you what they're doing is they're saying, we worry about this new constitution because it could lead to a military dictator. And remember what the thing about Julius Caesar is that he was a bit of a demagogue. He had a lot of popular support, but most importantly, he had the support of the troops. And so what they were worried about is if we had a popularly elected president who was the commander-in-chief of the troops, commanded the armies, and then would be basically, he'd be unstoppable, right? And it's kind of happened from time to time. You think of Andrew Jackson after the War of 1812. You think of Ulysses Grant after the Civil War. You think of Eisenhower, although Eisenhower was like the psychological opposite of Julius Caesar, but still, military victors have a lot of political cachet. And one of the I think it's a forgotten factor about our founding, how concerned they were about the possibility of a military dictator. And so at the interesting, the way the Constitutional Convention begins is that the Virginians get together and they prepare a plan called the Virginia Plan. It's presented by Governor Randolph, but it's James Madison is the principal author. And the seventh resolution, there are 15 resolutions in the Virginia Plan. The seventh resolution is the one establishing an executive. And it provides that the executive would have two powers. He would carry into execution the laws of the nation. So when Congress passes laws, he'd carry them out. That was not the controversial part. And in addition to that, he would exercise the executive rights of Congress under the Articles of Confederation. So in order to understand what that means, you have to look at the Articles of Confederation. And the Articles of Confederation give to Congress a number of royal prerogative powers, beginning with peace and war. What does that mean? Under the British Constitution, even as of 1789, the king had a unilateral power. He could take the nation to war. Now, Parliament had to give him money for it, so there was a certain check on that. But he could declare war and the nation would be at war. He could make treaties on his own without going to Parliament. Number of other things. These are prerogative powers, or powers vested in the crown by virtue of being king and not because of Parliament. And so they're outside of parliamentary control. And if you look at the Articles of Confederation, there's a list of, you can see about 10 of these royal prerogative powers, beginning with peace and war. And so when the Resolution 7 is presented, young Charles Pinckney from South Carolina, you could almost hear him gasp in the pages of Madison's notes. He goes, why, this would give the executive the powers of peace and war, which will make him a monarch. And at that point, I think this is the most dramatic point in the entire convention. Madison writes in his notes, a considerable pause ensued. Wow. It's like they're all sort of taking this in, and they don't know quite what to do, because there has never been in the history of the world an energetic executive with enough power to provide for effective administration, but who is not a monarch in any extended territory. There are a few small principalities, but in any extended nation. So they don't have any models to draw on. And to make things harder, George Washington is sitting right there. He's just been elected chair of the Constitutional Convention. He's sitting right there. Everybody knows he's going to be the first president. How do you talk about the dangers of tyranny from a president when the first president is sitting right there? I mean, if Joe Biden were sitting here, we have everything we talked about the dangers of presidential power, it would be about him. Right, well, more
We
so.
tell them it's about, Ron DeSantis coming afterwards.
Yeah. Well, I think the beginning of wisdom in thinking about presidential power is always to think about not just the presidents you like, but also the presidents you dislike. And so I think, I started this book while Obama was president. And it was about halfway done when I thought that Hillary Clinton was going to succeed him. Then along comes Donald Trump. What a great time to be writing a book, because I was forced, I'm not going to tell you which of these people I like and which of these people I don't like, if any. To need to write every word in light of very different presidents, I think was a good discipline for me to try to not be a partisan one way or another. So I really recommend whenever you think about issues of presidential power that you always think of the presidents you don't like as well as the presidents that you do like. So anyway, so George Washington is right there. And I think that the entire construction of the executive at the Philadelphia Convention was written from the point of view of Charles Pinckney's shocked statement, because what they wanted was a president with sufficient power to be an effective executive, but not to be a king. And the jury is still out on whether what they did actually worked, but we can talk about the various devices that they used to try to make that work.
Well, and extraordinarily, Washington had the good graces to step down, and not to try to continue to be a military dictator, not to try to be a military dictator, not to try to stay in office, despite the absence of term limits.
And he could have.
He certainly could have.
And his stepping down after 2 terms is an enormously important precedent.
That's right.
There's also a little appreciated thing about George Washington that made him especially trustworthy and that we are very fortunate about. Total chance, he had no sons.
Good point.
Think around the world, when republics are created and you have a powerful popular leader, there's a real tendency to go to the son. And if you look at the first 5 presidents, only one of them had a son. That son became president.
Michael, let's talk about war powers, because that's the first and most significant Article 2 power, arguably, that you identify as a prerogative that stemmed from the royal prerogatives. And what's so interesting about the way that the framers arranged war powers was to distribute the power of war and peace, as you say, over 2 branches of the federal government, namely to give Congress under Article 1 the power of declaring war, and to give the president the commander-in-chief power. Then Congress has another check on the president, which is of course the appropriations power. With these 2 checks in hand, nevertheless, the last time the US declared war was in World War II, and there has been, by many accounts, sort of runaway presidential action in the domain of military operations without checking with Congress. We have a mostly ignored or at least partially ignored War Powers Act that may rest on dubious constitutional foundations. We'll talk about that in a minute. But I asked you the question earlier today, did the framers' design around war and peace work? And let me ask you that question again because I loved your answer.
Well, it worked for a long time, but I actually think it now has failed. But I also think there's a reason why that is true. To take one step back, though, you have to ask yourself, what does it mean to declare war? Because that is not, it's not obvious what the verb declare means. And there are serious scholars, I'm not persuaded by this point, but there are some serious scholars who believe that to declare war is nothing other than to establish the sort of legal, the juridical status of war under which, under international law, the nation has the right to do certain things, and that you can draft soldiers and et cetera, the legal condition, but that it doesn't limit the power of the president to send troops into action. That's the view that I take on and disagree with. But I don't want to tell you that there's nothing to it. I mean, it's a position that I don't agree with, but there's something there. But my view is, and I think the history strongly supports this, that they understood declaring war to mean initiating war. And early on, each of the first three presidents faced the question of whether they could unilaterally send troops into action, and each of them came to the same conclusion that they had the power to respond to an immediate attack, but they did not have the power to invade. They didn't have the power to engage in an aggressive war action. And even Hamilton, who was the advocate of probably the strongest advocate of presidential power among the prominent framers, even he took the position that the president did not have the power to initiate a war. So I think that's so when we see that Congress is given the power to declare war, I think we have to see that means that Congress is the institution that is empowered with deciding whether to go to war. And then the president is given the commander-in-chief power, which is the power to conduct the war. And that's an interesting division of powers. And then how do you end a war? Well, they thought in very formal terms, you end a war with a treaty, and that's also divided. The president negotiates the treaty, but 2/3 of the Senate have to approve the treaty. So I think at each of these steps, they were very careful to not to have one branch controlling everything.
So let's hang on, let's go back to the initiation of war for a minute. The Senate just voted to rescind the 1991 and 2002 AUMFs, the authorization for the use of military force in Iraq. And interesting, the House had previously voted to rescind the 2002 AUMF. Of course, House has changed hands, so we don't know if this will pass. The president has indicated that he will sign it if it does. And so we may finally be rescinding one of two critical AUMFs that initiated the war on terror. But the question arises whether or not the passage of an authorization for the use of military force by Congress is sufficient to satisfy the declare war power. Now what happens, of course, is that Congress passes an AUMF, or the president takes unilateral military action without an AUMF, and then Congress votes appropriations, because nobody wants to be seen voting against supporting our troops once they're already out there. And then, using the Youngstown framework, everybody says, you see, Congress agrees, with the president, who is.
Because they were silent.
Because they were silent, or worse, the appropriation signal agreement, right? So on your framework, how do you analyze that?
Well, first of all, I do think that authorizations, AUMFs, I do believe are sufficient to justify the president sending troops into battle. This is a controversial position. Some people say that it has to be an actual declaration of war. Now, what's the difference between a declaration and an authorization? When Congress declares war, that puts the nation at war, and the president is then under an obligation to pursue that war to hopefully a successful conclusion. An authorization for use of military force gives the president the authority to go to war, but it doesn't start the war, it doesn't require him. And it's actually a very useful device, because that if we're having a controversy with another nation, the president can go to that other nation with the AUMF in his back pocket, right? And he can say, look, if you don't do what we want you to do, if you don't get out of Kuwait or whatever it is, then we're going to go to war, and I have the authority to do that. So it enables him to have one last chance of negotiating peace. So I think it's actually a very practical device, but it also has historical support. So in both of our first two conflicts, under Adams and Jefferson, the quasi-war with France, which is a really interesting area for thinking about war powers, and then the naval war against the Barbary states in North Africa. In both instances, the President Adams and then President Jefferson went to Congress for an authorization for the use of military force. So I'm fairly historically minded in the way I think about interpreting the Constitution. And I think that when Adams and Jefferson both take the same course, they were in opposite parties. It's not, when they are on the same page on a constitutional issue, I think that carries a great deal of weight.
So when we talk about, however, the 2001 AUMF, for example, this completely open-ended authorization to use force, with no sunset period, no geographical restriction, and then which was subsequently interpreted in an incredibly broad manner, so that the authorization to fight the Taliban and Al-Qaeda became the basis for our fighting ISIS in a different country many years later. It's also been the basis for our continuing operations in Syria. So when we think about presidential interpretations of these AUMFs and the general unwillingness of administrations to relinquish them, what can we say about war where powers have recent administrations sort of outstripped their either constitutional or statutory authority?
Well, Congress is kind of in a pickle when they draft these, because let's talk about the sunset. Should it end on a certain date? Well, if you pass an authorization for the use of military force up till September 17th, you're telling the enemy that on September 18th, they can do whatever they want. It's like, it just is not a smart military strategy. And it's very hard to draft one of these things in a way that is going to be both militarily sensible and also provide much constraint.
The
So I think it's very difficult.
President could come back to Congress. President could come back to Congress, right? Seeing that the authorization is going to run out, right? Surely, and extraordinarily, even after we had pulled our troops out of Afghanistan, and President Biden had more or less said we're no longer at war, Tony Blinken, the Secretary of State, was testifying to Congress that we still need the 2001 AUMF because we're still at war.
Well, it's just like as the COVID emergency ended, the presidents like to have it both ways. It's a difficult, I don't have a solution for how to draft an AUMF that's going to withstand this. There's a real, there's also practical problems. So the last time Congress actually declared war was World War II. I think that the first war, which was, in my books, by my way of analyzing the Constitution, illegal, was the Korean War. And this is a war where President Truman took us to war on the authority of a United Nations Security Council resolution. Now, I read my pocket Constitution pretty carefully, and I don't see the United Nations Security Council as being the body in the Constitution that authorizes us to go to war. I think that's important for international law, and I think it's very important for a responsible conduct of foreign policy, but it's not, has nothing to do with legal authorization. But so what has happened? There is a very practical change between now and the founding that has made the president, enabled presidents to take us to war in a way which was just not possible. I mean, unilaterally take us to war in a way which wasn't possible at the beginning, which is at the beginning, we did not have a large standing army. Under Washington, the army never got to be much larger than 1,000 men, and most of them were stationed on the frontier. There was no navy at all until Jefferson. And so when we contemplated going to war for the first time in the quasi-war against France, President Adams needed an army. He went to Congress to raise an army. They had to appropriate money to hire 10,000 troops, when the standing army, the regular army, was a tenth that size. So that means Congress debates the appropriation. They debate the raising of the army. So quite apart from the power to declare war, the president is just simply powerless to start a major war unless he has a standing army to do it with. Well, today we have a standing army of over 3 million men and women, and it's the most powerful fighting force ever. And when President Obama took us to war against Libya without congressional authorization, he went for 8 months without needing an appropriation because he was just drawing down the appropriations that had already been made for the standing army. So that's not a change in the meaning of the Constitution, but the effect of the Constitution is very different when the president has to go to Congress to ask for money versus when the president can already has the money basically in the bank and can simply do it.
And he had the help of the Office of Legal Counsel that wrote one of the worst opinions.
Claire and I were comparing notes on this earlier today, and our hearts beat as one. In the Libyan affair, the Office of Legal Counsel, which is it's a unit within the Department of Justice that gives binding legal advice within the executive branch. So it doesn't really bind anybody else, but it binds within the executive branch. They decide legal questions. And when things are properly operating, the OLC can be an important internal check on improper and illegal executive behavior, because there have been numerous times in American history, including somewhat recently, where OLC says to the president, no, you just don't have power to do that. And those are times when, you know, my heart soars as a patriot and a lawyer, and I think this is the way the system is supposed to work. Well, sometimes it doesn't work. And the OLC issued an opinion on the Libyan war, which is it's really pathetically badly reasoned. And essentially it says, it gives several criteria for when the president has the authority. First thing is he has to think it's in the public interest to go to war. What good does that do? Of course he thinks it's in the public interest to go to war, or he'd be doing it, right? So that's not a limitation at all. And then it says that it has to be limited in expected duration. Well, everybody hopes a war is going to be limited in duration. It may or may not be, and most of them aren't. And then the absence of actual troops on boots on the ground, actual because the Libyan war was an air war. It wasn't an invasion with infantry. Well, our very first actual war was the war against the Barbary nations. You know, the Marine hymn, the halls of Montezuma and the shores of Tripoli. That the shores of Tripoli was the war against the Barbary states. It was a naval war, and so and Jefferson recognized it as a war, and Jefferson thought he had to go to Congress for authorization for it. The idea that just because you don't have infantry involved, it isn't a war, I consider really really strange. And then there's this final bit about not expecting substantial casualties. Well, remember the Libyan War? How many American casualties were there? It might have even been zero. It was exceedingly small. But were there casualties? There were hundreds of thousands of casualties on the other side. And do we not take into consideration, when considering the importance of going to war, what the implications of the war are going to be for the other side? I think that's not.
Well, especially civilian casualties, because there are always civilians.
And when in an air war you're especially likely to have large numbers of civilian casualties. So.
Now, speaking of spectacularly bad OLC opinions, we have to cover this before we leave the topic of war powers, which is the August 1, 2002 memo by my former colleague John Yoo and his then comrade in arms Jay Bybee, who wrote a memo saying that enhanced interrogation wasn't torture, but anyway, even if it was, the federal torture statute, 18 U.S.C. 2340, would be unconstitutional if it tied the president's hands in matters of war. Now, on your account, that falls under the category of residual presidential powers, right? Can you explain how you analyze that
there's a
memo?
Chapter about this, and let me try to just lay out very simply. The Constitution gives the president, enumerates certain prerogative powers, just like the Crown had prerogative powers. They're powers that the president exercises by virtue of his office, and the Congress can't do anything about them. He can veto whatever bills he wants, he can pardon anyone he wants, etc. These are the prerogative powers. And then there are other powers that are vested in Congress, and Congress then empowers the president to carry them out. That would be like taxation. The president can't impose any taxes unless Congress in advance authorizes it. No, by the way, no congressional silence involved in any of this, right? And so So taxation, spending, borrowing, going to war, criminal law, these are all things that are vested in, powers that are vested in Congress. And the president can act only because in advance of that act, Congress has authorized it. But I argue in the book, and this is not, plenty of people will disagree with this, but here's my argument. I think it's right, so I'll tell you what I think. Is I think there's a third category of powers, which I call residual executive powers, because the Constitution lists a certain number of presidential powers, but it's obviously not a complete list. The Constitution says nothing about foreign affairs, for example. There are a whole bunch of things that presidents do. They've done them all the way back to George Washington that are not listed in the Constitution. Are they just making it up? I think not. I think because the first sentence of Article 2 says the executive power is vested in the President of the United States. I think, and this is controversial, but this is my view, I think that that is an actual grant of powers of an executive nature that haven't elsewhere been dealt with in the Constitution to the president. So I think that's where the president gets the authority to do all these other things. But some people say, oh no, that clause doesn't give him any power at all. And that's implausible to me, because that means there are all these powers that presidents routinely exercise that aren't mentioned. Are they just behaving unconstitutionally? Other people, including John Yoo, whom Claire just mentioned, say, well, okay, yes, there are executive powers, and they are constitutionally vested in the president, just like the pardon power or the veto. My reading of the text and the history is that these residual executive powers are vested in the president, but that they are not prerogative powers. That is to say that they are subject to the supervening acts of Congress when Congress is acting within the scope of its enumerated powers. So in the so-called torture memo, the OLC reasoned that the president has the authority to decide how to treat captured enemy soldiers. That's a lot of history behind that. That's true. That's a traditional power of the commander-in-chief is to decide how to treat enemy soldiers. But, and here's where the OLC opinion falls down, it fails to mention that Congress has the power to, and I'm quoting now, this is from Article 1, Section 8, Congress has the power to make rules and regulations for the conduct of the armed forces. And the OLC memo argues that if Congress does something that cuts into the president's executive powers, that's unconstitutional. I think that that's not true. I think that the president does have the power in the first instance to decide how to treat enemy soldiers, but that when Congress passes a statute pursuant to its power to make rules for the conduct of the armed forces, that supersedes executive power. And I think there's this whole category of powers which the president can exercise without having to go to Congress first. So it's not like taxation or spending or these other things where he needs to be authorized. He can do it by virtue of being president, but Congress has full authority to regulate, to take it back, to regulate it, to forbid it, to exercise its power. And this, I think, was an important way in which the framers understood that this executive was going to be powerful, yes, but not a monarch. It makes the president subordinate to Congress when Congress actually acts. Not like Justice Jackson's three-part test. It isn't silence, right? It's actual, an actual decision by Congress, and we're not in a twilight zone.
Right.
Congress wins. It's a clear,
Right, so-
it's a clear categorical proposition.
Right, so let me clarify that and make sure everyone understands, make sure I understand. So in this case, you would say it's a conflict between an act of Congress and the residual executive powers of the president as to how he wants to treat enemy soldiers, but we've got a federal statute that forbids torture. Therefore, the federal statute wins out over the president's exercise of his residual powers.
Exactly.
So let me give you another case on a different topic, because I want to make sure that we get audience questions in. And so far, we've only covered one of the many issues in your book, namely war powers. But I want to talk about obstruction of justice. So Congress has passed obstruction of justice laws, and now I want to give you a hypothetical, because the issues of this sort came up all the time during the Trump administration. And I want to give you a clearer case. We had the case of President Trump firing the director of the FBI, Jim Comey, but I want to give you an even clearer case. Imagine that he had apparently intended to try to fire Robert Mueller while Mueller was conducting his investigation. So let me give you the hypothetical that he had actually succeeded in doing that, and that he had fired Robert Mueller, and that he made no bones about the fact that he had fired him because of that Russia thing, right? As he said about Jim Comey, namely because Mueller was investigating him. Obstruction of justice or valid exercise of presidential removal powers?
Well, neither one, actually.
Okay.
The regulations under which Mueller was appointed vest the appointment and removal of the independent counsel in the Attorney General. The Attorney General was recused, so it was actually the Deputy Attorney
Right.
General, Rod Rosenstein, who was the authority. Now, Trump could fire Mueller, but the way he has to go about it is he has to tell Rosenstein
Right.
to fire Mueller. This is just like Nixon
And
and
the
the Saturday Night Massacre. You may remember Nixon wanted to fire Archibald Cox, but he didn't just fire him. He ordered Attorney General Richardson to fire him, and Richardson said no, and so Nixon does have the power to fire the people he appoints, so he fires Richardson, and then it becomes the Deputy Attorney General, William Ruckelshaus, and Nixon says fire Archibald Cox. Ruckelshaus says no, and so he says you're fired, right? And that's what would have had. That's what would have had to happen. Rosenstein would have said no, and Trump could have fired him, and I don't even know who would have been the next in the chain of command.
And by the way, the
there.
one who eventually fired Archibald Cox was none other than Robert Bork,
That's
right?
right.
Who was Solicitor General. So, but so let's assume he did it that way, right? So you go on down the chain and so on. But I want to be clear, it's a case in which he says, I'm doing it because he's investigating me.
Well, what he's going to do is he's going to say it's an unjust and improper investigation, and it is and it is hurting the interests of the United States, because when the president is being, as it did hurt the interests of the United States, when the president is under investigation, there's a whole cloud, and it's very hard for the president to be able to deal with foreign affairs and so forth when he's under investigation. And so that's what he would say. It's in the public interest for me to fire him.
Yeah, but we know he's doing it.
Not to mention the fact that he'll also say it's a witch hunt.
Right, well, we know he's gonna say all that, we also know why he's doing it. So it raises the same clash, doesn't it, ultimately,
Well, so
between
the question
congressional
becomes,
law and
when the
presidential
president
action?
is actually exercising a constitutionally vested authority, can he be prosecuted for obstruction of justice on the theory that he has a bad motive? I think that's very dubious.
Or a demonstrated matter.
If somehow we knew for sure, if we had a magic ball and we could tell what somebody's motives are, I think in theory he could be prosecuted, but we can't. And I think what you do when you say that he can be prosecuted is we're saying 12 jurors will decide whether he has exercised constitutionally vested authority for a proper reason. And they were not elected president, he was elected president.
Right, so let's go on to another one of these presidential powers, then I'm gonna let, actually, two more brief ones, then I'm gonna solicit questions from our audience. But we have 3 OLC memos, while we're on the topic of OLC memos, that say a sitting president can't be indicted, right? And these have guided, of course, as well, Justice Department policy. It's been Justice Department policy for a long time that a sitting president can't be indicted under federal law. Doesn't govern state law. Now, is that constitutionally mandated, or is that prudential policy that is not particularly enshrined in the structure of the Constitution?
Well, we don't really know. It could be policy, it could be a constitutional command. The argument that it might be a constitutional command is that impeachment is the constitutionally specified means by which to discipline a wayward president, and you would say that that's the exclusive means. The issue would not have occurred to the framers because they assumed that they didn't imagine independent prosecutors, so they assumed that the president was in charge of prosecuting, and of course he wasn't going to prosecute himself. So it just wasn't, I think it would have been inconceivable for them to imagine that could come up. It's only our creation of these independent councils that make that an issue.
Right, now when we talk about presidential privilege, executive privilege, though, I mean, we're talking about a whole host of presidential powers that are, I think you would call them residual powers, right? So what about the assertion that I don't have to testify, I'm the president? Well, the Supreme Court has shot that down a few times. And most recently, the claim by some close advisors or cabinet members of the president who were called to testify in the January 6th, before the January 6th committee, who tried to assert executive privilege, and the Supreme Court shot that down and said that, in fact, no executive privilege applies here. How do we think about Congress's, struggling to assert its subpoena power and its investigatory powers and presidential assertions of non-enumerated presidential powers to thwart that?
Well, let me give first a conventional and then an unconventional answer. The conventional answer here is that actually the Supreme Court did not hold that there is no executive privilege. What they held is that these officers could be called before Congress and that they had to assert executive privilege with respect to any specific questions, but that they weren't immune by virtue of their office from having to present themselves.
Well, especially someone like Bannon, who was never in office,
Well,
tried
the
to claim
Bannon
it as
claim
well.
is really not,
Yeah.
he had a very weak claim.
Right.
No matter what you think of executive privilege, surely it doesn't apply to private citizens who aren't, part of the executive branch at all. But it would be a harder question with respect to, say, Pence, or with respect to the White House Chief of Staff, or folks of that sort. And the Supreme Court in the U.S. v. Nixon, the Watergate tapes case, clearly said that there is executive privilege to protect the ability of the president to get candid advice from his officers. It just said it wasn't absolute. So there is an executive privilege, at least according to the, Supreme Court doctrine, there is a privilege, and that's why it has to be evaluated on a sort of question by question basis. Now, the unconventional answer is, it's a little unclear that Congress has the power to subpoena people anyway. Outside of, there are 5 specified places in the Constitution where Congress has the authority of a court, and the most important one being impeachment. And I think there is no doubt that in the course of an impeachment inquiry, that Congress can act, when Congress is acting with judicial power, that Congress can subpoena not just the president, but the aides and anybody else that it wants, and it can compel a testimony. But what was the January 6th committee doing? They weren't an impeachment inquiry. Supposedly they were looking into the possibility of legislation, but that's really pretty much of a pretext. It's Congress, nothing in the Constitution gives Congress the power to subpoena people in a congressional matter. And this came up at the Constitutional Convention. And it was, actually it was our friend Charles Pinckney again, who moved to give Congress, give each House of Congress, which means separately, not, you don't have to get both House and Senate, each House of Congress would be given the power to define its own privileges, which would include the privilege of subpoena and contempt. That was voted down, but something happened first that was, I think, is kind of interesting. Madison spoke up and he said, well, I don't think that that's a good idea. I think that should, instead of having each house able to do that on a case-by-case basis, there ought to be a statute. The Congress ought to have to pass a statute, pursuant to necessary proper. He didn't say that, but that must have been going on in his mind. Authorizing it, and then it would be prosecuted, the contempt would be prosecuted in the ordinary course. And then he said that if the executive was subject to this, it would need its own privilege. So the interesting thing is the Constitution is actually silent. It doesn't give Congress the power explicitly to subpoena, and it doesn't give the president an explicit executive privilege. But Madison basically said, if you're gonna have one, you've gotta have the other.
That's fascinating. On that note, let's invite our audience in to ask questions. I'm sure there are many of them. Please, go ahead.
Professor,
If you can introduce yourself before you ask your question, that would be wonderfully helpful.
And could I ask, for some reason, when my plane landed, my ears still haven't cleared, so please
I'm gonna give
be
you,
loud.
I'm gonna briefly hold the mic. I'll hold it for you. Here you go.
Professor, my name is Richard Salkowitz. I'm in the community here. The question is related to the war powers and treaties. The Congress, if I remember my political science from a long, long time ago, treaties are binding on the country and on the Congress and the executive. And in that case, can a president act in pursuant of a treaty to go to war, like the NATO treaty, for instance?
I don't need
Go ahead,
that. I
go
don't need
ahead.
your
No, you don't
microphone.
need my
I
mic.
can answer
No.
with my own microphone. That's a great question, and that was one of the arguments that President Truman made. I think that that's not right. So when we say that treaties are binding, I think what we mean by that is that they're binding as a matter of international law. That is, we have an international law obligation to follow the treaty. But the United Nations Treaty says explicitly that the nation states will follow their own constitutional processes in carrying out those duties. So I think that that means that, yes, we may have had an international law obligation, but that we still have to go through, for purposes of internal constitutional law, we have to do that. It's also the case that the United Nations didn't require member states to go to war against North Korea. It was they called on member states to go to war. So I'm not sure that we could say it was a treaty obligation exactly.
Jules.
Yes, Professor. My name is Jules Zacher, and I'm on the CERL.
Hang on, wait for the
Sorry. Thank you. My name is Jules Zacher, and I'm an attorney here in Philadelphia, and also on the CERL board. The question that I had is, particularly in the nuclear weapons arena, do you think that nuclear weapons, particularly with the president's sole authority to use them in this country, do you think that in any way changed the balance of power between Congress and the executive branch?
Yes. I don't think it changes the meaning of the Constitution, but it does. I mean, when the framers left to the president the power to repel sudden attacks, that they were not thinking about anything that was going to be like irrevocable in the way a nuclear response would be irrevocable. So I think the president, the same constitutional power can be, much more potent under one set of technological circumstances than another. Just like I think that when the commerce power was given, and power to regulate interstate commerce was given to Congress, it meant one thing when most commerce was local and there wasn't much interstate commerce. It means something very different now when we have nationwide markets for almost everything, from eggs to shoelaces.
My name is Adam Thirschwell. I am a lawyer for the federal government, let's put it that way. I have the question about subpoena power and Congress got me thinking. If the executive has residual powers, does Congress have residual powers? And if not, why not? Equal branch of government. And if it has any residual powers, then it seems like the power to subpoena, given all its other powers, including to conduct oversight, and it would be completely disarmed if it didn't have that residual power.
So the answer is no, Congress doesn't, and all you have to do is look at the language of the first sentences of Article 1 and Article 2. Article 2, the presidential power, is the executive power is vested in the president. Article 1, which is the legislative power, says all legislative powers herein granted are vested in Congress. So the initial vesting clause is limited to the powers that are actually listed after that.
Can I quickly follow up and ask you, that's a nice textual reason. I mean, is there any rationale behind that 270-year-old coincidence that they use those words in one and not the other? I mean, is there any, why would Congress not have residual powers?
So what the framers did, they do have something they wouldn't have considered them residual, but we do have a necessary and proper clause. So the Article 1, Section 8, Clause 18, after there's a list of 17 specific powers, it says that Congress has the power to pass all laws that are necessary and proper to carry into effect the preceding powers. Now, the way they thought about that, I think, is not that these are residual, like powers that weren't mentioned. I think it's that Congress isn't, in carrying out the actual enumerated powers, Congress can go beyond their very specific words in order to carry them out. So just a simple example, Congress is empowered to create a post office. Well, at the very beginning, they passed a law saying that anybody who steals, robs the mails that's a criminal offense. Well, that's in order, if you don't protect the post office from, highway robbery, then it's not gonna work. And so that's necessary and proper in order to carry out the congressional power. But that doesn't mean that they can pass laws about, something else that doesn't happen to be mentioned. Like, and most of what we're concerned about here are powers that are traditionally lodged in the states. So family law, for example, is something that's just traditionally vested in the states, and it's not given to Congress. And they can't just say, well, it's a residual power and we're going to exercise it.
Thank you. It's been a pleasure listening to you and the discussion and delving into the complexity of Constitution and its implications. There is another question which you had used, the issue of public interest, that it's really against public interest. But I think, well, for instance, in the example of authorization of war, the declaration of war, the question of public interest, I think, merits a debate, because in a divided world where you have liberals and conservatives and Democrats and Republicans, whose interests, which public's interest would be considered in that, and how do you resolve that?
Well, sensing the way, the direction from which I think you're coming, I think I agree with you that the idea of a public interest is not a judicially manageable standard, because if 50% of the people think one thing is in the public interest and 50% think the other, who are the judiciary to say that some are right and some are wrong? But for our elected officials, I think that's exactly the judgment that they're supposed to be making. And they are elected by us to exercise good judgment with respect to what's in the public interest. And so I do think that the president and the members of Congress should have the public interest very much in mind. But I think the judiciary is not in the public interest business. It's in the law business, not the public interest business.
A comment on your, David Harrison, I'm an alumnus and a lawyer, on your subpoena, on the power of Congress to subpoena, your example that they can pass all laws necessary and proper. Of course, if they have the subpoena power in each house, that's not the law, that's a different kind of action. But I was going to ask you how Trump had the power to abrogate the Iranian nuclear treaty, which was, I believe, passed, it was an act of
It
Congress.
wasn't a treaty, wasn't a treaty.
No,
But
it's
that
not
was
an
passed as a
executive.
treaty.
JCPOA was not a treaty.
That's what I'm saying, it was an act of Congress.
No, it wasn't. It
No.
wasn't executive
No.
Congress either.
It's not, no.
Okay.
It was a unilateral, when one president, see, presidents sometimes like to do things the easy way, by not going
Right.
through Congress. And when they do that, when it's just on their own authority, the next president has just as much authority to go the other way. It's like building a house on sand.
I'm with you, I thought there was an act of Congress.
But this is, let me just borrow yours for a minute. This is a very important topic, because what we see is presidents avoiding having to go to Congress by using less and less, trying to ensconce what they want to do in foreign relations by way of treaty. So they also try to avoid having to go to Congress with their appointments. And President Trump used this a lot, declaring everybody to be acting so-and-so and delaying the moment at which they would take this to Congress. And that's another topic that we talked about earlier today. Perhaps you want to comment on this.
Well, the issue of acting is actually not a constitutional issue. This is a statutory issue. Congress has passed a statute allowing the president to create acting positions. They can only last until the end of the next congressional
right.
term and so forth. And I think there are too many of them. But it's often the case that Congress gives presidents a certain leeway because it's practical to do that. And you need acting people because it takes a long time to go through confirmation and all of this. And if the president doesn't abuse that power, all is well. Everybody's better off as a result of it. But then along comes a president who doesn't just use it in an emergency, and not just when it's really necessary, but makes it a routine matter. And this has happened in a number of areas of law over the nation's history. This happened with Richard Nixon and impoundment. Some people in the room probably remember impoundment. This is where the president refuses to spend money that Congress has appropriated for a particular purpose. Well, presidents exercised this power, all the time before Nixon, but they did it because they were making savings. Let's say Congress appropriates $8 million to build a post office, and the president is able to build a post office for only $7,500,000, so he doesn't spend the remaining amount. Everybody's happy. Or an appropriation is made for a purpose and it turns out not to be necessary. Everybody's happy if he doesn't spend it. Nixon was the first to blatantly and repeatedly and frequently just refuse to spend money, not because of any savings or change of circumstances, but because he disagreed with the policy. And as a result of that, Congress passed the Impoundment Control Act, and now presidents don't have the power it's been taken away altogether.
What
And
about
I think the acting business with the appointments could lead to that Congress could just get fed up and the president would be deprived of a useful interim measure.
But does that apply to President Trump's refusal to convey funds to Ukraine?
I'm sorry.
But that act doesn't apply to President Trump's withholding funds from Ukraine, I take it.
Withholding funds from what?
From Ukraine.
Oh, Ukraine. Actually, it does.
It does, okay.
It does. The Comptroller General actually issued a formal ruling that the delay in funds to Ukraine was a violation of the Impoundment Control Act.
Very good, yeah.
It's in the book, by the way.
Thanks for the reminder. Gary.
Good afternoon, Gary Deutsch, alumnus and attorney in town. One of the problems with having an Apple Watch is you're never really disconnected, and my watch has been blowing up with news that supposedly, at least CNN is reporting that Trump's now been indicted in New York. And my question is there any limitation on the right of the ability of a state to indict a sitting or former president? When you were talking before about, don't think of it through the lens of, the president that you dislike or like, but think about it in the other direction. And so, for those who may be very happy about this, would they be as happy, for example, if President Biden was now, indicted at some point by Texas or some other state? Is there a limitation on the ability to do that? If there isn't, should there be?
So I can only give an opinion because there isn't precedent on this and there isn't history on this. I think former presidents are they're private citizens. So I don't think Trump has any protection from prosecution by virtue of being a former president. I think sitting presidents may very well, we don't know, and actually Claire and I were talking about this earlier, I would not be surprised if courts held that a state prosecutor could not indict a sitting president. There's no direct precedent on that, but I think it follows logically from structural principles that it's just too dangerous to allow, local prosecutors to be able to basically halt the operations of government. And some prosecutors are really out of control. So.
Sir,
Hang on one second, wait for the mic.
hello again, Dave Johnson, Executive Director from CERL. I was just wondering, with the last statement you made, procedurally, couldn't the Justice Department get the case removed to federal court and then have a federal judge stay the state prosecution until the president was either out of office or something along those lines, or it's unsettled?
Well, if it's a sitting president, yes, the department could move to federal court, but then at that point, I don't think there's anything in current law that entitles the president to have it dismissed. I think that would be my guess is that probably would be the result, but it's never happened, right? So we just don't know for sure. Way back, I don't know if you remember Clinton versus Jones, where Paula Jones sued Bill Clinton in a civil suit. This isn't criminal. And just to show what a bad predictor I am, I thought the Supreme Court would say that that suit had to wait. It would be, not that it would go away, but that it had to wait until he was no longer in office. Unanimously, 9-0, they said that suit could go on. I was surprised, and I wonder if the case you put is a more extreme version of that. So, for the same reason that I thought they would protect Clinton then, I think they would protect the sitting president now. But criminal action is a much more severe matter than a civil action.
Though in Trump v. Vance, they made very clear, and that was a 7-2 decision, that a sitting president could be criminally investigated and that no person is above the law. So this was a very, very strong opinion from a very conservative court.
That's right, but that was a subpoena not against the president, but against
A third party.
a third party, namely the bank.
Right.
And I think that's different.
So now that we're gonna close shortly, but now that this has apparently happened with Gary bringing us this news, you said you're a poor predictor. What do we predict will actually happen with now a former president being indicted?
I think Alvin Bragg's case is so weak. Surely he's being given advice by his own political supporters not to bring
You haven't
those
seen the
charges.
evidence. You haven't seen the evidence.
I'm sorry?
You haven't seen the evidence, Judge.
I
Says
have
you
not
haven't seen
seen the evidence. What we know is that even if Trump did exactly what he's said to have done, it looks contrived. But Bragg should sit on it and wait for the for the special prosecutor to investigate the federal crimes and/or the Georgia prosecutor to investigate the crimes having to do with the interference with the Georgia election. I think to try to charge him for, hush money to a prostitute is just,
She wasn't a prostitute.
I think that is not going to go over well. I think that would backfire.
All right, well, we shall see.
Somebody,
One more.
Didn't they charge John Edwards with paying someone off? Wasn't John Edwards criminally charged with paying someone off?
and acquitted.
Okay, but he was charged. I mean,
He was
it's not,
charged and
it's not
acquitted
that
by the
those
jury
offenses have not been charged.
for very similar.
But let's remember, the indictment is brought not on having paid hush money, but on campaign finance violations. So that's a very important distinction. So arguably, there's a campaign finance violation here, it's a different matter. But we shall see, and what do you expect coming out of the special counsel?
I really don't know. I think that's gonna be a situation where it does seem, it certainly appears that a crime was committed. But it's a Hillary Clinton situation when is it, are they going to indict for withholding, for improper treatment of confidential documents? We'll see. I wouldn't be surprised.
All right, on that fascinating note, thank you so much, Michael McConnell, for being here. Thanks to all of you, and will you please join us for a reception right out here outside the room.